Well, good afternoon, everyone. Depending on when you're tuning in, might be morning, but welcome. 4 p.m. Eastern Standard Time. It's the time for Speaking Legally, where the legal meets the cultural. We're here 4 p.m. every Wednesday with our legal experts, Royce Russell Esquire, Edward Pichardo Esquire, and myself, producer of the show, Dr. Stacey N.C. Grant. Thank you for being a part of our family. We are here in season 2. We started this in the midst of all the crazy we were seeing in this global pandemic, bringing you real time news and information and helping you to understand it, not only from the legal perspective, but from the cultural perspective. Because we know when America catches a cold, Black America has pneumonia. So we're glad that we do have the experts here to dive straight into the topics of the day. But before we do that, I'm going to allow them to say hello. We know the trial that's going on, so hold on. We're going to get there, but there's some other pressing news that we'll be discussing. Hey, Kevin, thank you for joining in. Hey, Deborah, great to see you. Hey, Richard. All right, over to you, Mr. Russell. What say you today as we begin our show?
Well, there's a lot to be discussed, and I think what is should be on everyone's TV. Forget watching the nightly news at 11:30. You need to watch the recap of the George Floyd prosecution of police officer Chauvin. I think that should be a historical moment, a historical watch for all households. Whether you're watching CNN, whether you're watching the Black News Channel, whether you're watching MSNBC or HLN, and we know you should be watching Speaking Legally. So we know we're going to do an analysis on it. But I just want to welcome everybody to another date, another time, another episode, so we can enlighten the mind.
Thank you, Mr. Russell. Mr. Pichardo, buenos dias, mi amor.
Sí, buenos dias. Once again, my name is Ed Pichardo. Buenas tardes. Good afternoon. I believe you're going to find this show very fulfilling and educational. We have quite a bit to discuss here. Definitely concur that all of you need to be watching this Floyd trial. It can be catched on several mediums. In particular, don't sleep on YouTube. I was able to actually catch, a snippet of, or not just a snippet, but the entire opening by defense counsel. Because I know some of us can get pretty fatigued if you sit there and just purely watch the trial and the testimony or whatever arguments, because, you got the questioning, the back and the testimony, and then the exchanging of documents. And, for some people who aren't necessarily lawyers or folks who are, extremely interested in this stuff, you want to take it in certain doses. And so, please feel free to get on there and catch actual parts of the case, and that's how I was able to wake up this morning while I was making my coffee. I was listening to defense counsel's opening statement.
Yeah, I think this is I'm gonna put a plug in for the Black News Channel. I think it's time that if we want to really look at issues that affect us, that's where you need to be plugged in, because they're showing the trial, and the commentary is endless. And it should be, because we're seeing, history being made in real time. And we often talk about, the prosecution of police officers, which rarely happen. And now we have one that's being televised, and we don't need to have 10 or 15-minute commercials or see the national network say the same thing over the same thing over the same time over the same faces, but just different places. So tune in to the Black News Channel and tune into us, so you can get a robust analysis and commentary as to what has happened and what will be happening in the future.
Absolutely. It will be televised this time, so there's a lot to watch. So we're going to get into what has already happened. But before we do that, there's some local news that is recently been shared, and it's talking about qualified immunity, something that we talked about on this show before. And, it's interesting to see how everything is playing out in the world in real time. So let's just jump right on into New York City moving to end qualified immunity, making it the first city in the U.S. to do so. So what does this actually mean, gentlemen?
Well, let me just jump in and say one thing before we start. The the devil's in the details, right? And so before we start dotting the I's and crossing the T's, it says the first city. And Ed, we had this discussion. What does that mean, the first city, right? Is the first 5 boroughs? Is that what, because, when you sue, you're suing in state court, you're suing, the NYPD. And so I don't want anybody to confuse it with the fact that, I can do this in Mount Vernon, I can do this in Scarsdale, I can do this in New Rochelle, first city. So that is a limitation in and of itself. And I think we've come to the conclusion, what I think rightfully, we'll find out in the long run, the 5 boroughs. So this is a limited scope, and the word city sounds very dramatic. New York City moves. Yeah, New York City moves what and how and when and how far. And that's what we discuss.
And you make an interesting point because actually what we're talking about basically is that this is a piece of legislation that was passed by the New York City Council. It's an amendment it's a local law amendment, an amendment of the New York City Administrative Code. There have been similar laws that were passed by the state of Colorado and enacted and Connecticut. Okay. There has been in the past, I believe, Senator Zelnor Myrie introduced a bill in the New York State legislature, but it did not pass. It was introduced.
Now, hold on right there, Ed. Now, you jump from city council to legislature. Legislature. Which one holds more weight?
Well, it would naturally be the state, because if it's a state law, then it covers the entire state. Right now, this bill, if it's signed by the mayor of New York City, it will cover the New York City, basically the 5 boroughs, the jurisdiction of New York City, not outside of it, because it's a local law. So you are absolutely right. It is limited in scope. Don't get me wrong. As a lifelong New Yorker, born, bred, and raised here, I'm proud that, I live in a city where the New York City Council saw fit to pass such a law. But I think it would be much more comforting to see this law passed statewide. Okay.
Right.
And I believe in some of the discussions that we've had, there is, a bit of concern in terms of applicability, jurisdiction. Will there be instances where some practitioners will possibly find some sort of conflict between, the state law and the local law, even though there's notwithstanding language within this legislation that seems to say, hey, listen, anywhere where there's some notwithstanding any conflicts with the, with the state law, this is what this local law seeks to do. Okay, fine. But,
well, you and I, we've gone back and forth with this, and quite admittedly to all our viewers, I know I don't have real stronghold on what it all means, right? And just in talking with you, I think you have a little better stronghold, but the headlock is real loose. The guy's wiggling out. You got him down, pinned to the floor, and by the time the ref goes 1-2, the guy is standing. He's not even on the mat anymore. So, and when you and I, we discuss a lot of things for all of our listeners and viewers. Maybe you don't know. We go back and forth with understanding and try and have an understanding of the law. And I just think, given how convoluted this city ordinance, law, or whatever you want to call it is, that we probably should bring some other folks in. And I think Dr. Grant has helped us with that.
Absolutely. And it's always a pleasure when we can add other voices to the conversation. So welcome to Attorney Jerry Graves to Speaking Legally.
Thanks for having me. I'm Jerry Graves. I operate in New York and New Jersey as a civil rights lawyer and a employment law lawyer. Yeah, we were looking at that law. I reviewed it and I looked at other sources, and it looks like the law has been, that has been passed by the New York City Council, which is the lawmaking body for New York City. where they are making the laws that make up the administrative code of New York City, where the council passes these local laws that pretty much affect the day-to-day lives of persons living in the 5 boroughs of New York City. So if there's a cause of action that occurs in New York City, and the plaintiff has standing to bring that cause of action to any court in New York, so they could file this claim in the New York State Supreme Court, because what the law does is it provides a private right of action to sue in any New York State court. The NYPD and the police officer in their individual capacity, as well as any other officers that fail to intervene to stop the unconstitutional behavior. So clearly, this is a great law for the 5 boroughs of New York, of New York City.
Well, let me ask you this question.
Before you ask the question, Mr. Russell, we have a question from the audience. If you could save that, Kevin is asking, can the city ruling set some kind of precedent as it relates to state cases?
I think that the precedent will be within the body of law that the New York City Council writes, which is the administrative code. I don't think that it will set any precedent with respect to New York State laws or even federal laws. This is something that's specifically written for to protect the residents of the city of New York.
Well, I have a question for you and or a statement. It's saying it's giving the citizens of the city a right. Now, maybe I might be mistaken, but did we not have that right before? Like before this ordinance was passed or is going up to the mayor, didn't we always have a right to sue for forced arrest, for forced detention, for excessive force? Is this adding some more teeth to what you and I could bring any other day in any other court pertaining to a citizen that may be stopped?
I think the teeth that's added is that with this particular law, pursuant to the Section 8-804 of that particular law, when the police responds to your complaint that you file in a New York State court in the 5 boroughs, the police cannot use qualified immunity as a defense.
Can you define that? What is qualified immunity?
Basically, it's a judge-defined rule. It's a judge-made rule preventing the filing of civil rights lawsuits against the police or any other government official performing his or her official duties under their conduct, where their conduct violates clearly established law that gave the defendant officer fair warning that his or her conduct was unconstitutional. So it's basically an immunity against suing the police for financial damages. And what makes qualified immunity so abusive to plaintiff lawyers is that they have to prove to the court that there is a body of law that clearly indicates that what the police were doing was unconstitutional. And that's a very difficult test, and that what the courts are looking for is, an analogous set of cases and case precedent at pretty much every level of the judiciary, the Supreme Court, the appellate courts, as well as, local courts, that says that your set of circumstances that you're pleading has to be analogous to a set of circumstances that's already precedent in the courts. So they're looking for this almost identical case to support the particular case that you're putting in court. And that's a very high bar. And the courts have been ruling against, plaintiffs pretty much 3-1 on this particular issue.
So if I'm a regular guy, which I am, right, and I'm bringing this lawsuit, I represent my client, bring lawsuit. He or she is illegally stopped. One, I could feel secure enough to know that I could bring this because this is what we call an inalienable right now by city, right? The city is saying you have a right to bring this, right? And so then I bring this lawsuit, and the police in past times have always used even if we did something wrong, we're immune from our wrongdoing because we are police officers. are they stripped from that defense, or is it a fact case by case basis, or what is the end game? Me representing my client and bringing a case to court.
This new law that the city council passed it stripped you of that defense. It's gone now. You can't use it. You know, so if you bring a case, you know, in New York State courts within the 5 boroughs, that's a you know, an excessive force case, for instance, they have to dismiss your case on other grounds, but they can't use the qualified immunity defense.
And so I would imagine that also holds true for, and this is where we really see some of the qualified immunity. You know, I practiced in civil rights for years and kept litigated them for years and settled them for years. Sometimes I have cases where the officer either doesn't have a warrant or have misinformation on a warrant, and they go into the wrong place and they go into the wrong location. And usually what happens is the city will try to strike this defense of qualified immunity. You know, like, we acted in good faith, but we got the wrong place. Does this change that scope, since qualified immunity is no longer in existence if the mayor signs off on this? I'm right, Ed. The mayor does have to sign off on this, right?
Yeah. I mean, the mayor, in order for this to become law, the mayor has to sign. That's what we call enactment. If I just may chime in, frankly, I think in reading this law that you know, it doesn't stop. It's not going to stop a judicial review of the reasonableness of the search or the seizure. Okay, there's going to be some sort of factual analysis of what exactly happened here. So if you have a plaintiff that comes with a case where the police department is going to be able to argue that the officer's actions were reasonable, let's say in your scenario of the search warrant, that officer is able to somehow say, hey, listen, these are the facts that I had at the time that, you know, I executed the warrant. Somebody else made some sort of clerical error that, pursuant to, you know, I had a document in my hand that told me A, and that's what I went. It may have been wrong, but I acted in good faith. One of the things that I also want to point out is that I'm not comfortable with this bill in terms of the bare bones way in which it gives, one, this right of security against unreasonable search and seizure, and two, it's simply saying that qualified immunity is not a defense. I know that there are other, like, for instance, I believe in Colorado, the statute is much more explicit in terms of it addresses all of the elements of qualified immunity and making it clear that you can't rely on those elements to then invoke qualified immunity. Here, it kind of just says, oh, you know, qualified immunity is not a defense. And I'm wondering if later on some courts are going to somehow find that, you know, it doesn't sufficiently prevent the invocation of this qualified immunity defense, especially if you have these facts that kind of lean towards, hey, listen, you know, this officer acted, quote unquote, in good faith.
Well, I'm struggling with the statute in itself. I heard what you said, Jerry, and you know, and I read it also. It is now you cannot use it as a defense. I'm struggling with what type of teeth it has, because the certain bells have not been rung. And Jerry, we've talked about this, and Ed, we've talked about this. If this had some serious teeth to me, then I'm wondering, where is the Pat Lynch's of the world? You know what I mean? That sits, you know, the NYPD, you know, benevolent association director, right? Where and why some of the advocacy groups are not really like marching around saying this is a victory for today. And I'll read you something that I sent out, and I asked one of the, you know, advocate groups. I was like, well, you know, does this ordinance or this new law have any teeth. And what that person said was that, quite frankly, the media is lying, and that the impression that qualified immunity is dead is not really true. And these are folks that are on the ground. They help push forth, trying to do stuff with 50A, and they're not really buying into the fact that, off with the head of qualified immunity. I mean, I won't be satisfied until I see it on paper where the city doesn't allege it anymore.
Well, I think once the law is signed, the bill is signed by the mayor, certainly anyone seeking to file a civil rights claim based on excessive force or any Fourth Amendment type claim will try and file that claim in the New York State court if the action occurred, if the violation of the right occurred in one of the 5 boroughs, and so we'll see what happens. We'll see. Whether we'll see what the defense attorney is going to do. When they get that complaint, will they make an argument that qualified immunity is still alive here in New York, and so we'll see how the court deals with that.
I know from a practitioner standpoint, I may turn a blind eye now to federal court and say, hey, look, let me litigate everything in state court.
Definitely.
I mean, I'm gonna shine the light back on you, Jerry, in that why would one stay in state court rather than go to federal court, given this new law or proposed law with qualified?
There's no reason to do that. And if you're filing if you have a case where your family has retained you to represent them in an excessive force case, where the police have killed their son, right now you want to file that right there, in a New York State court, because according to this new law, you can't bring a qualified immunity defense. You would not want to go into a federal court with your arguments,
because federal court still believes in that. And then we're seeing a lot of that. I mean, we have states saying we're legalizing marijuana, but we have the Fed saying, hey, look, not so fast. We have legislation like this. The city is going to be the first to do certain things, eliminate qualified immunity, but when you go in federal court, they're like, not so fast. It's still in the play. There used to be a time where, and the reason why I say used to be is because I'm looking at this legislation. I'm looking at Section 8-805 of this legislation, and it talks about the court having the ability to do injunctive or other equitable relief. And we've been trying to have the state court do something other than pay out for the longest. They say, oh, we can't terminate, or we can't suspend, or we can't do anything. By reading this, and I ask for your analysis on this, both of you brothers, attorneys, it's saying that now the court can give some type of relief after that. It says an individual or employee thereof, the court shall, in addition to awarding other relief, including injunctive or other equitable relief, as such the court deems to be appropriate. That's a big bite.
Well, the big bite is that they're also requiring the loser to pay the attorney's fees,
and that's one of the reasons why. So let me backtrack. And I don't want us to be in the clubhouse of the attorney rooms, and none of our listeners and viewers really understand what we're talking about. Because no, it's important. It's important because we're going to keep on this horse. I'll just explain briefly. When you bring these type of lawsuits, when you bring wrongful death, excessive force, false arrest, battery and assault, these type of lawsuits that you see, our great departed, Johnny Cochran and, myself, you, Ed, Crump, when we bring these lawsuits, one of the things that also the city, the municipality, the state has to consider is what we call attorney fees. Because not only does the family get compensated, the attorneys get compensated for the work they put in. And so based upon this statute, and we already knew this, it was implicit, but now it's more direct. Attorney fees can fluctuate depending upon the person who's litigating it. And in this legislation, it talks about how attorney fees is determined by the experience of the litigant in this area. So a guy like myself who's been practicing in this area 20, 20, 21, 22, 15, 18 years, have litigated wrongful death cases, litigated all type of cases on the spectrum of forced arrest, police brutality. My attorney fees and hourly rate might be $1,500 an hour, $2,500 an hour, right? And someone else who might be less experienced, who's been doing it for 5 or 6 years, their hourly rate might be $500 an hour or $300 an hour. And what the court will do is look at your background, look at what you have done, and the court can say, all right, now you get attorney fees. So for every hour that you worked on this case, that money is granted back to you. That's a big incentive to resolve and settle a lot of matters.
Man, I think another thing to look at here is the whole issue of liability. I just want to point out that this version that was passed by the New York City Council is an A version. And so there was an earlier version of this law that was introduced in the city council, and that actual bill
that was a Royce Russell bill. That was the Royce Russell bill. You can spell it. Why we call it the Royce Russell bill? Tell me why we call it the Royce Russell bill.
We call it because you called it on an earlier show. You felt that in order to stop these officers from doing what they have to do, they have to personally feel it. And keep in mind here, we're talking about this immunity, but we're also talking about indemnification. Who is it that pays out when this either a judgment is made or a settlement is reached? It's the city. And the earlier version of this bill had the police officer paying either 5% or $25,000, whichever was lesser of the settlement.
Boy.
Dr. Grant, and all our listeners out there and viewers, this sounds like chapter 12 of Cardiac Arrest.
It does.
Guide on how to handle unlawful police stop, published in 2018, stating that you can look at the chapter, get the book. I've seen the movie before. That the police have to be personally liable. Now, I didn't go as far as 5%. I gave him a break. I said 1%. Right?
You softy.
But you
had the foresight.
I grew up in the valley for your folks that know. I'm soft. You know what I mean?
Okay, really? That's what we do it. That's what we do it.
But no, I was looking at 1%, 2%, and this had it at 5%. And now you look at the legislation, it says A next to it. What is it? I forgot the number. The number is 2220A. And so now it all makes sense, Ed, because remember the mayor and the commentary, and I discussed this with Jerry, the commentary, the mayor was saying, I wanted to make sure that the police officers had some protection. And I really didn't understand what that meant. But now I do, because now if you take out the liability standpoint of percentage-wise of your check, and you say, all right, we're just going to get rid of qualified immunity. Now we say, hey, man, I gave you something. You gave me something back. What's the problem?
And the reason why I mentioned that, too, is because we're talking about, you guys just talked about injunctive relief, right? Because at the end of the day, our sincere belief is not just the families, but the activists, everybody that is concerned with this whole issue of excessive force, police brutality, deprivation of constitutional rights, want it to stop. And so in many cases, when you talk about the injunctive relief, right, you're looking for the judge to make an order enjoining the city from doing certain things or ordering the city to do certain things that will lead to the cessation of this conduct. And and I link it also to this personal liability issue too, because I also share the belief that until some of these officers start personally feeling it somehow, they're going to continue to engage in this conduct, because at the very least you want them to start taking the de-escalation training more seriously. You want them to start thinking about, okay, because listen, I've actually gone visited on 2 occasions the police academy out in Queens, the NYPD Police Academy. It's a beautiful complex. They actually have an actual area where they train officers how to deal with certain conflicts. They have a mock apartment. They have a mock grocery store. They have like.
Do they have a mock cultural learning center? Because that's what they need. They need
no.
Do they have a mock 21-story project that you got to go up and do a vertical? Do they have a mock of that? Do they have a mock of, my son wearing a hoodie walking down the block? Because a lot of the cultural and sensitivities or lack of sensitivities and the classism that we always speak about, I don't know if you can really train or do anything about.
Well, before we get in, because I agree. I mean, we can be on here for a while. Kevin has a question. I want to make sure we address that question and push a pin in that conversation, because you put it in the book. You warn people about this. You might have given them the idea. But anyway, Kevin says, so do you think that based on what you just said, Royce, less cases will go to trial?
No, I don't think that. I think the city has a way of doing business. They will not cave to the media pressure of what's going on in the United States at all. Given what happened with George Floyd, Breonna Taylor, even Michael Ferguson, you can name Michael Brown and Ferguson, you could name a litany of cases that have happened throughout the United States. It may not necessarily happen in New York City. The city is pretty much taking a stand that we'll get to you when we get to you. Like, I'm trying to resolve cases on a weekly basis prior to trial. And that's not because I don't believe in the case. I'm looking at the trauma that is set upon individuals that have been victimized, and then they go to trial and they have to revisit the victimization. And, don't want to relive that or want to move on and can't and want resolution. And the city has their formula. And they say they want to settle cases and they want to resolve cases, but they will take the slow wheel to justice any day of the week. Now, you may not see me standing in front of a courtroom every day or every other day litigating these cases because they don't want me to tell that story, but they will drag it to death, because anybody of color that are trying these type of cases, whether pre-George Floyd, post-George Floyd, tells this type of story, in most boroughs, it's going to resonate. So, no, they'll just make sure that it goes away, but goes away slowly. Very slowly. I mean, Jerry, we're litigating cases in Jersey that's been laying around that we up in the appellate court, right?
We just got out the appellate court. Well, we're still in the appellate court. They have to make a decision on a case that we've been litigating since 2014?
Yes.
Yeah, 2014. The AG's office is just, making every motion they can possibly make.
And on a case where the violence is 0 to none, and we just talk about deprivations of one's rights. So you would think, to Kevin's question, that would be a no-brainer.
Yeah, this is a case where there's really no real injury, a low damages case, but they litigated it, for 6 years, and now we're at the issue of qualified immunity, and that went to the, we won on that issue in the lower court, but now they appealed it to the appellate court. Now we're in the appellate court, waiting on a decision. So that's why this particular law we're dealing with here, would be great, because now a lot more cases will get into the court system, because lawyers are now willing to take these cases because they know that the qualified immunity defense is a very high bar.
Now, I don't know if we want all that, Jerry. I don't know if we want all the lawyers to start taking the cases. I think we want to keep that little claim to ourselves, but you know what I'm saying? But I get the picture. More lawyers might be interested, but
they will be very interested.
I wanted to bring up some guys to see what you think. This law also seems to put in a 3-year statute of limitations, and
That's
the statute of limitations, and we discussed this, guys. You got your 90 days to put in your notice of claim, right? And you got a year to bring suit normally. So how does this all affect that? I'm just not sure. I mean,
I would admit I am very, very gray and hazy on that. And I know marijuana is legal in New Jersey, and I'm still hazy on it right now on what they're talking about.
Why are you hazy?
No pun intended. Yeah.
Because as we know, we have, like we said, a year and 90 days. Now you're saying 3 years, and we know 3 years goes to negligence. There's a 3-year statute of limitation. But some of these causes of actions are assault and battery. Those are 1 year statutory type of causes of action. So I don't know where it plays. Jerry, do you have an idea where it plays?
The statute of limitations issue.
Yeah, because they put down here on section 8-806, they're expanding it to 3 years. And
but they're using the term notwithstanding, right?
Yeah, they use the term notwithstanding 50K, which leads you to believe that the other statutes are still in play, but then they say 3 years. Look, I don't know if we have the answer here, and sometimes in speaking legally, we don't have the answer, but I guess the real takeaway is that you really need to engage with an attorney if you're going to climb this ladder. That's what you should really do, because now we're getting statutory funky with things. And, you know, I like the old rules. You got to file your notice of claim, get your case in within a year, 90 days. This way, if it is 3 years, fine. I got it in time. If it's not, you're not caught up in anything.
No, but let's talk about that, because as Jerry was mentioning earlier, in terms of a lot more lawyers, I know, you know, but hey, you get the plaintiff who comes into the office who is talking about something that happened a year and a day ago, a year and 2 days ago, and you're like, damn, are you barred from suing, or do I go ahead and test this law that says 3 years? And then if I'm able to get past the statute of limitations hurdle, you know, that's pretty damn amazing. How many people have you turned away because, you know, too late? Sorry.
Yeah, I think it's going to be. I think it's going to be interesting to kind of figure this whole thing out, because part of the whole legal phenomenon is putting the city on notice, right? And so now you have a 3-year statute of limitation. Nothing's been filed. Whether or not this law, when it becomes law or it becomes legislation by the mayor signing off on it, is it going to be prospective or retroactive? I didn't read any language that said retroactive.
Well, I wouldn't take any chances on anything retro. I would say, you know, once it's enacted and the language stays effective immediately upon, you know, enactment, then you know, I would say anything prospective. You know, you argue if they come back with the defense, oh, the notice of claim wasn't filed, or you didn't file suit within a year, even though it was filed, the notice of claim was filed, you go ahead and cite this law if it happened within the 5 boroughs, and see what the judge has to say, and says, wait a minute, this does say, you know, 3 year statute of limitations, and, you know, it was invoked, and it was named, you know, it was part of the complaint, so it's clearly cited to. So,
well, I think it's interesting that as we talk about it, I've been flashing the article up, that we also have the George Floyd case happening in real time. So
yeah,
the article is on and being covered here at ABC News. They're showing what is happening in the court, and that's where we're headed to next in our conversation. So we'll be watching what happens if this does get enacted, and what that really means. You know, there's still some question marks, but, you know, we'll give a kudos. Let me see if I can put some applause on for Mr. Russell being ahead of the class with putting that in cardiac arrest, that this is one of the only ways to effectuate real change if there was a financial piece to it. So any closing comments on this before we move into what's happening in real time?
I would just say one thing. I think what Jerry brought out in reference to the legislation, which should not be, I mean, actually, which should be highlighted, really, like put an exclamation point, quotes, you know, put it in bold, underline, do everything you can to understand that it really puts some more teeth in failing to mitigate, failing to intervene, failing to interrupt. And that's what we're really pushing for, us as citizens and lawyers, when it comes down to other co-conspirators. And I'm using the word conspirators, officers that stand around and do nothing, or officers that stand in front of the person that's trying to video what's going on, or use their flashlight to prohibit any type of videoing of misconduct. I think that is a power play in this legislation. Now you can actively use that as a cause of action, although I've used it before, but now it has some real teeth. Failure to intervene.
Well, what I would say here to close on this topic is that I would invite our audience to take a closer look at this law. It's bill number 2220 hyphen 2021, meaning the year that it was passed by the city council. It's on the New York City Council website. It also there's also a memo that's attached to it. It's a plethora of information. It also gives you some insight into the negotiations that apparently took place as to what was ultimately passed. And also look at it for yourself to see if you feel like the media is telling you the truth, that this is the quote unquote end of qualified immunity in New York City, because I'm sorry, I'm just not completely convinced. I'm going to have to see what goes down in these courts, how these judges rule on this law and how they interpret it. Because just for the audience, judges interpret laws that are passed by legislatures, either on the city, on the state, or federal level. Ultimately, the judges decide what this law really says and its effect. So, for me, I really want to see what happens, because I think some of this wording, some of the more effective wording that this legislation could have contained was eventually shaved from the final version, including the part about the officer suffering some personal liability for the conduct.
Mm-hmm. Great point, and to be continued. And that's why we do the show. This is where the legal meets the cultural, so we can really understand what's going on. And we know that as we open the show mentioning this particular trial, this is history happening right in front of our eyes. And it's interesting to see the New York Times put out this article where they're doing what I would assume is their summary to bring everybody up to date on what's happening on the trial. But there have been some triggers that have happened as everyone is viewing, listening to some of the interviews on the stand. And we want to just touch on some of that. This tribute gathering, I'm not going to play this right now, but folks are gathering. They're nervous about what's going to happen. Why are you nervous? Because we've seen this movie before, and we're really wondering what's going to happen as a result. And we did an in-depth show about the charges that are actually being presented, where the burden of proof is. So I'm curious to get the take from both of you, well, three of you, with our special guest, Attorney Graves here, on what you see unfolding in real time on this case.
Well, I would be a rude host if I didn't let our guest speak first. So, Jerry, why don't you give your take on it?
Will probably defer to Brother Prachado, because now I'm still looking at the case in real time, not completely up on the case, but what I've seen so far is that there's just a wealth of evidence against this police officer. My guess is that they've met their burden, and that a jury should, make a decision, against this police officer that murdered, Mr. Floyd. And if we don't get that particular verdict, it's going to be a lot of unrest in the streets, is what I believe.
I mean, one of my concerns here is that not so much a complete acquittal, because I agree with, Jerry, that, the prosecution is going to be able to meet their burden. The issue is if you get that one or two rogue jurors that decide to not find this defendant guilty, and it results in a hung jury. And at that point, you don't have a conviction. The state has to retry this officer, and I think people are going to be very upset. The community is going to be extremely upset about, this this inability to effectively convict officers who engage in clear misconduct. There was an addition of a charge that had been previously dismissed by the judge, and maybe that'll alleviate some of those concerns in terms of the burden, in case you have that juror that says, oh, the homicide wasn't intentional, but the officer did engage in some level of reckless conduct that led to it. I viewed the opening statement by defense counsel, and he seems to be going kind of in this direction that the officers, while they were, in particular his client, while kneeling on the victim, Mr. Floyd, was distracted by all of these people that were surrounding them, saying things to them, and that somehow caused them to somehow not be able to pay attention to what they were doing. And also he seemed to be pointing to some differences between the initial coroner's report and medical reports that came later as to the cause of death. He seems to be highlighting the ingestion of some drug that possibly led to the ultimate cause of death, and saying that, you know, it's not beyond a reasonable doubt that he died from something other than this pressure that was placed upon him by this officer and the officer's conduct. You know, my issue, and you know, and listen, he's defending his client, no doubt. I just hope that none of these jurors find that defense plausible. It was refreshing to see the lady who was an EMS, I believe, worker, who happened to come upon the scene and was trying to offer some assistance and saying to the officers, hey, listen, that guy looks like you're hurting that guy. And she got into a back and forth with defense counsel and said, wait a minute, you don't know my job, so you can't sit here and try to argue with me as to what I'm seeing. I mean, it's, you know, that was some pretty powerful testimony. I found it in terms of, you know, against the defense and pro the prosecution in terms of, you know, what was happening here in real time. I mean, it's, you know, it's been an interesting case to say the least.
I think when I look at any case and I do any commentary on a case, I look for what we call tall tales of truth. And one of the tall tales of truth that I'm seeing in this case, which the defense has to be careful with, is that the witnesses that come on that stand, you have to be very careful with how you approach them and what you say to them. I think there is an element, and I always say this in every case, there is culture and class that walked in that courtroom in many of the cases, especially when the defendant is African American, or the defendant is a person of color, or the case involves a person of color. And here we have that. We have that dynamic. We have that culture. We have that class, all playing a factor in how a jury may come out on this case. There was one witness that even testified and said to the defense counsel, I'm not going to allow you to paint me as an angry black man. Wow. I mean, that was a shot that just, like, you know, you want to talk about red face? Like, how do you even come back from what I call a tall tale of truth? How do you come back from a tall tale of truth of the store employee who says, but for the fact that our manager had this rule that says that if somebody gives you a counterfeit bill and you accept it, it comes out of your paycheck, I would have never went outside and said, hey, my man, what's going on with the funny money? Alleged funny money. And regrets the fact that he even did that. You know, when you talk about the EMT, defense counsel, he scored what the naive person who's watching the trial would think, right? Because the trial is a marathon. It is not a sprint. So you may get some nice questions in today that make you feel good. You got some nice questions in today that was highlighted on TV. But what is the trial and how the trial is going in your favor or against you over the long haul? So when you're arguing with the EMT about whether or not George Floyd was frail as she described it, and he's really not frail. And he's trying to make the point that he's actually bigger than what he is. And he might be arguing the wrong point, because the other point is that no matter how big or how small, 3 people were on him with all their pressure, as she testified. And why is it when it comes down to people of color in trying to give aid or anything that is empathetic or will escalate, you need to know who I am? One of the points defense counsel was making, well, did you have ID on you? Did you tell the police you were EMT? What difference does it make? Do I have to tell you that my godfather is Bill Russell before you slap me on the ground and step on my neck? Is that got to be my card? My card got to be, I am Jerry Graves, the son of the Graves family for Essence or whatever, before you slap me on my head? I mean, why do I have to give you data points of who and my background and my family is for you to treat me differently? It shouldn't happen. And I don't think that defense is really catching hold to that. And today, Brother McMillan, who was on the stand today, he just started crying. He was the one that was saying, just get in the car. Just, you're going to lose this one. You can't win. And I think defense counsel, finally the light bulb went off in their head to say that we're not even going to question this guy. We just want to let him go. Just have a seat. But my last words on this is that I think what America is really seeing, not only when it comes down guilt and innocence of this case, but America should be seeing that they're doing critical thinking. And then CNN and MSNBC and all these other stations really need to get to the Don Lemon, you name it. What they really should get to is that what is happening in this trial is not only a police officer being convicted or being held responsible. That's surface. To me, that's surface. It's important. It's historical. It's highly necessary, but it's surface. What's underneath the surface is that you're getting a view of how Black folks live their life. Every time a guy gets on that stand and says, "Oh, I thought a police officer surrounded him, so I pulled over and got out." Why is the guy pulling over and get out when he see another African American surrounded by police? Because he knows something bad is going to happen, and he wants to prevent it, and he wants to be a witness to it, and he wants to stop it. Right? Why, when people are having nightmares and they talk about trauma to the witnesses that were testifying today? Shit, that trauma has been going on a daily basis when there is no cases.
I think
down the street, when they're getting beat down, when their brothers getting beat down, when their sisters getting beat down, you're highlighting the trauma because they're witnesses in this case. Bruh, this has been happening for a very long time. Let's turn on the light and stop using the flashlight. Let's turn on the headlights. This has been going down. And that's the underlying story that America really needs to know. It is the tale of 2 lives and how law enforcement chooses to deal with people differently. And on top, we should go to jail.
Could you actually make that argument in the closing argument?
Hell yeah. And that's why I can't believe that I'm still sitting here right now.
That would be very effective. I'm already sold on just the witness testimony, especially the EMS, young lady that was walking by and where she stated that she's just traumatized because she couldn't help this man.
And that's a white woman.
Yeah.
Who's probably never been stopped in her life, who's probably never been abused by police or law enforcement, who probably has reverence for a law enforcement. Hey, look, we live in America. Most powerful people, white man, white woman.
And if I may, what was so powerful for me in her testimony was because he kept trying to get her to say, "Wouldn't you have been distracted? Wouldn't you have been distracted?" And she was like, "No, we're trained to do our jobs under stress. We do what we have to do." This idea, because all of this kind of secretly plays into these stereotypes of, you got this officer in a high crime community. Of course he's scared. Of course he's nervous because all these people are surrounding him and all of this and that. Oh, this guy is huge. Because he was, defense counsel was making with respect to the witness who was the 911 operator, he was trying to say, well, don't you see the truck shaking back and forth when he was in the truck, kind of making it seem like, oh, Andre the Giant is in there and the truck is shaking. That's the reason why all these officers had to come down on him.
And to your point, see, sometimes less is more, right? Less is better because, when you watch the whole video, right, and in the car shaking because George Floyd is getting out on the other end because he said he's claustrophobic. Now, if that was a white guy in a suit and a tie who got arrested, and he says, "Please don't put me in this vehicle. I'm claustrophobic." You think they would have still threw him in the vehicle? They'd have sat his polite guy, CEO guy, whatever class prejudice you have, on the sidelines and made sure that he didn't have to do that. The man wasn't saying I wasn't going in there because I don't want to go in there. He's saying I'm claustrophobic and I'm sick or what have you. So there are things here that what we call stubborn evidence, which is the video, they're never going to be able to combat no matter what they say. And that crowd was like 5 people. I had more people in my basketball team than that crowd.
Well, as per usual, our show is coming to the close, and everything you said, I think we're all seeing it. All 3 of you have made points on what America is looking at. I'm putting this image up because as a woman, as a Black woman, as we're closing out Women's History Month, when every day is a day to celebrate women, I'm putting this up here as a mother of 2 Black sons. And this is a scene from Queen Sugar. So shout out to the OWN Network. If you want to pick up Speaking Legally, we're here. But this was a scene from the show where they had to have a conversation with their son, because what they're doing is reliving all of the incidents that happened in 2020 in this new season. So they're going through COVID-19, the pandemic, and the George Floyd murder. And this was a moment when the son, with tears in his eyes, trying to figure out the talk, that the world is learning about, the talk that we always do. And this embrace was the mother, the father, and the son after having the talk of the reality in America. So at the very least, when people are confused about the protest and why Black Lives Matter, why we need to say that don't all lives matter, this to me is a symbol of the pain of Black America and the pain of parents when we realize what our reality is in this country, and this innocent young Black boy having to be sat down and told that just because of the color of his skin, nothing to do with his education, with the social choices he might make, the school he might go to, but just because of the color of his skin, he has to be made aware of what to do in confrontations with law enforcement. I've been crying through the whole season. I don't get to watch TV often, but I catch this particular show on the app. And the emotions that I felt in real time witnessing George Floyd's murder came right back up again, just watching a show. And that's the power in the narratives that we can control, because it raises the conversation that this trial is bigger than George's death, because it speaks to a long history of what we've experienced as a people in this country. And I really hope for all of the allies and sympathizers, you're starting to understand what the reality is and what we're fighting for when we see this trial unfold. So we'll be speaking about this on future shows, because this trial will be going on for a while. And everything that we're seeing, be very clear that it will affect our future generations. What we might not live to see, this case is going to be a part of history. So with that, I'm going to give my co-host a chance to give their final words, and we're going to close out Speaking Legally today. And we'll be back at the top of the second quarter of 2021 with our show next week, as April is coming in. And what we hope is that April also brings some good weather. So there's some other comments in the chat. John said, yes, John, so little that it takes. And Deborah, thank you. Saying a powerful show. Kim, thank you for your commentary. We appreciate you, Kevin, for always being here as well. And Richard and Rolanda and everybody that tunes in, shares this out. This is where the legal meets the cultural. We're doing our part to add, to amplify the sounds for change and reform, and just being aware as a community. So we'll start with our guest, Attorney Jerry Graves, Esquire. Thank you for joining in and adding your commentary today. Any final words?
I just want to thank you, Dr. Grant, and my brothers Russell and Pachado for having me here. It was a great experience, and I love the show. I'm a big fan.
Thank you. Thank you. Senor Pichardo.
Well, I say to everyone, farewell. Thank you for watching our show, and we look forward to providing you with many more shows from here and to continue to discuss this topic and many others that are of importance to the community.
Thank you. And Mr. Russell, over to you.
I'll just ask that everyone, instead of watching the nightly news, whether it's Fox 5 at 10 o'clock or the news at 11 o'clock, tune into what happened in the George Floyd case. And make sure you up to date. Make sure that you understand what's going on, and you can mark where you've been and when history is being made and the trials, that you have seen. I think it's a moment to be reckoned with.
All right, everyone.